We're going to go ahead and get started, and I just want to remind everybody, most everybody's muted, but there's a few that are not. So if you're not muted, please mute yourself, other than our presenter and John. But want to welcome everybody to our March virtual meeting on property tax assessment and appeals with Bob Glowacki, and we're very thankful that he joined us tonight. We'll give a little intro to him shortly. And for those of you that don't know me, Jason Perro, president of the Apartment Association, I would like to introduce John Baldwin, who's one of the founding members of our organization, longtime board member and past president, to introduce Bob Glowacki, who will talk about real estate tax assessment appeals. So take it away, John.
Hello, how are you? I hope everybody is having a good evening. I want to thank everyone for attending our meeting tonight. My name is John Baldwin. I'm one of the board members of our association, been on the board since its inception. It really gives me great pleasure to be able to introduce Robert Glowacki tonight. He's a longtime friend of mine. He's tonight's speaker, of course, and he is expert in the field of real estate assessment appeals. Bob is president of Assessment Evaluation Incorporated, AEI, which was formed in 1982 for the purpose of assisting property owners with real estate tax appeals. They provide full service real estate tax appeal consulting and appraisals for residential, commercial, and industrial properties. Bob is a licensed real estate broker and a certified general real estate appraiser in both Pennsylvania and New York, and a certified Pennsylvania evaluator. He also owns Glowacki Management Company. AEI conducts residential, commercial, and industrial tax appeal related work in Erie County, Pennsylvania, as well as in 30 counties throughout Pennsylvania and Northwestern New York. They have been involved in thousands of tax appeals with very impressive results, and I've heard about some of them, and they are indeed impressive. Their philosophy is that a property owner should be willing to pay their fair share of taxes, not more than their fair share and not less than their fair share. They do this by providing objective, unbiased, and well-supported real estate appraisals and consultation to assist their clients in making informed real estate decisions. Will you please join me in welcoming Bob Glowacki?
John, thank you very much for the invitation. I think you've given quite a bit of information about my personal background. You and I talked briefly a little bit before this meeting started. Just this way of history, to remind, some people may or may not be aware of this, but prior to about 1980, the city of Erie maintained an assessment office, and those assessed values were utilized in calculating the Erie School District and the City of Erie tax, as well as Erie County had also and continues to maintain an assessment office. I was really a proponent of eliminating this dual service. I mean, if you're a property owner in the City of Erie, you're paying your county tax, and you're also paying to maintain an assessment office that was operated by the City of Erie. I was on city council. I started in 1978, and in probably about 1980, the City of Erie voted to eliminate the assessment office and simply to adopt the figures that Erie County was using. But for that couple of years that I was initially on city council, council was the Board of Assessment Appeals. And I quickly realized that they had people walking in representing particularly industrial and commercial property owners, and representing them and getting reductions. And at that point in time, you could do this work on a fee contingency basis. And Glowacki was smart enough to realize that I was on the wrong side of this table. And in 1982 is when I actually resigned from city council and started this tax appeal business. Just so everybody, I want to have everybody have a little understanding of terminology that is being used. And if you have any questions, you can butt in and let me know. But obviously everybody's familiar with an assessed value, which is simply a number that is utilized to calculate your tax. We're going to get into what does that necessarily represent as far as what it means in relationship to the market value of your property, but which I'd go into next. I mean, market value I guess by definition is put the property on a market, reasonable length of time, willing buyer, willing seller, how much will they pay for it? And again, we're going to touch upon the relationship between those assessed and market value in a minute. You'll also sometimes hear the phrase a predetermined ratio. In Erie County, and I'm going to try to stick basically with Northwestern Pennsylvania, but in Erie County theoretically assesses at 100% of market value. Warren County, for instance, who has not had a reassessment since I believe 1986, is assessing at 50% of theoretically the 1986 market values. And you can go down to Crawford County, and they have not physically had a reassessment since 1971. 1970. It's been 51 years since Crawford County's had a reassessment. Their predetermined ratio was 75%. So in theory, if you look at a total assessment in Crawford County, they are taxing at 75% of that number, and that market value that they're basing it on is 1970 market values. The point is, there absolutely no connection whatsoever to what current market values are. What occurred, and who was one of my teachers was John's father, J. Robert Baldwin. At that point in time, if you wanted to contest an assessment, I'm talking about early 1980s, the only value you could go after is to try to prove that your market value of your property did not represent your assessed value. J. Robert went the next step and spent a lot of time and I think a lot of money in developing what is the relationship between market value of a property and an assessed value. He reviewed and substantiated hundreds of sales within Erie County and ultimately went in and said, fine, you're assessing me at $100,000. I think my property is worth $100,000, but the relationship, the ratio, the percent of what an assessed value represented versus its market value was a number substantially different from that. That was kind of what was happening throughout Pennsylvania. And in 1981, there was a case, Keebler-Cookie versus the Philadelphia Board of Assessment Appeals, and it landed up in Commonwealth Court. Long story short, that is when they changed the laws in Pennsylvania to establish a common level ratio. Every month, every assessment office in Pennsylvania submits all their sales to the state tax equalization board. They weed out the non-arm's length, bankruptcies or share sales or one partner buying a partial interest in another. They're trying to come up with legitimate sales. They go through a statistical analysis and calculate what is truly the relationship between how much is my property worth and what is the appropriate assessment. That is what's referred to as this common level ratio. And to give you an idea how diverse this number is, in Erie County, which conducted their last reassessment in 2013, it's currently 86.2%. So if you can substantiate that you just bought your property for $100,000 and you are assessed at more than $86,200, 86.2% of your market value, that's a great basis for an appeal. In Crawford County, it's 26%. So if that same $100,000 property, if it was in Crawford County, it should be assessed at no more than $26,000. Warren County is 22.7%. So again, that $100,000 piece of property should be assessed at no more than $22,700. I think that those types of variance shows how dire some of these counties are in need of a countywide reassessment. And that's what you should do. Take a look at what your assessment is. you have a pretty good idea of what your market value is. And if you're in Erie County, if that relationship isn't about, about 86% of that, that is probably a good basis for you to file an appeal. There's some misconceptions as to also what type of methodology assessments office use and in computing your assessment. Erie County, I was involved in a tax case in the late 1996, where the Mill Creek Township School District actually sued the Erie County Assessment Office to force a countywide reassessment because they hadn't had one since 1969. It was Judge George Levin heard the case. It was a 2-week trial, ultimately resulting in his decision that mandated a countywide reassessment. The county appealed that decision to Commonwealth Court. Commonwealth Court upheld it. The county appealed to the Pennsylvania State Supreme Court, who did not have to, and they did not hear the case. But as a result of that, in 2003, Erie County had their first reassessment since 1969. They hired a company called Cole, Air and Trumbull to conduct it. They're a mass appraisal company. They conducted another one, which they actually did in-house in 2013. And those are the values that are currently utilized in Erie County to calculate your assessment. I know I'm asked often, if a person, you buy a property, you sell a property, does the assessment office then start changing your assessment? In Pennsylvania, there's only 3 triggering events. One is you've got a demolition or construction of that occurs at your property. You got a garage, you tear it down, you build a new house, you put an addition on your manufacturing plant. That is one of the triggering events that an assessment office can go in and change your assessment. But the values that they have to use in Erie County would be the values that they utilized in 2013. The county always has to go back to their base year. Now, whether they do it or not in other counties, I think Erie County is pretty good about it. But think about that. We're saying in Crawford County, you put an addition, you build a new house, you build an addition to your retail store in Crawford County. They're supposed to go back to the manuals and the values that they used in 1970 to set your assessment. Whether they do or not, we can spend a whole seminar on that one. But that is so you got new construction and demolition. The other is a subdivision of a piece of property. You got 10 acres, you divide it into 10 1-acre lots. The assessment office has the right to reassess those 10 new parcels. But again, they have to use the values that they were using for that kind of property back in 1916 or 2013. And the third is countywide reassessment. Those are the only 3 triggering events that a assessment office can change your assessment. Now, who can challenge your assessment? Obviously, you can as a property owner, based on what is the relationship of your property to its current market value, or you can go in and challenge your assessment based on the methodology and the values that were utilized in the base year. I actually did some work for the de-arments in Crawford County, the people that own Channellock. One of the sons built a new home, and based on the market value of that home in comparison to the common level ratio, he was overassessed. But I mounted a challenge saying, oh, we aren't going to do that. We're going to calculate it based on the values that you used in 1970. You want to maintain this ludicrous, outdated system, then we're going to play, we're going to play your same game. And that's exactly what we did. And it resulted in a very substantial decrease for that property owner. The irony is you can pick and choose which one is most beneficial to you. So if it's market value, current market value, and apply that 86.2% in Erie County, common level ratio, great. If not, you can utilize the methodology and the values that they used in 2008, 13, and also appeal. and whichever one is most favorable, you can pick whatever one you want as far as mounting that reassessment. The other party that can challenge assessments are school districts and municipalities. And when John introduced me, I've always felt that way. I firmly believe that a property owner should be assessed at no more than what pay their fair share. If you're underassessed, I work with that. The trial I had today that I was talking about before Judge Ridge. It was I was retained by the Mill Creek Township School District. They feel that the property was inappropriately reduced to something below market value. In the same breath, I represent a lot of property owners that are requesting reductions. And again, I think what's appropriate is pay your fair share, no more than your fair share, no less than your fair share. There are typically there's two ways in which a property owner can file an appeal. One of them is in Erie County, it's August the 1st. Every August the 1st, if you so desire, you can file an appeal and ask the Board of Appeals to review your assessment. You've got to prove your case as to whether it's a base year appeal or current market value appeal. You've got to provide the evidence, but you can do it on an annual basis. There is one exception to that rule. And for anybody who may have made any type of an addition or demolition to your property, the county will, throughout the year, update. You build a house today, and you literally get your certificate of occupancy. The county assesses that property based on 2013 values. They will send you a change notice. You have 40 days after you receive that change notice, at which time you can file an appeal. Let's say you filed it today, they might not have the hearing for a month or two, doesn't really matter. It would be retroactive back to the date that you filed it. So other than the normal annual filing date in Erie County of August the 1st, the only other time you could appeal it would be if you got one of these change notices. Not every county is the same. The county has got the right to adopt either August 1st filing date or September 1st filing date. But in all cases, the Board of Appeals has to hear all the hearings no later than October the 30th. That was actually one of the reasons the state gave counties the option to push that date back to August the 1st to give them more time to hear appeals. But that's it. It's either a change notice or the regular annual filing date of August the 1st, which is also the same date that if a school district or a municipality wanted to file an appeal, they'd be subject to that same August the 1st date. Just looking at a couple notes here. I explained how that common level ratio, as far as evidence that a property owner needs to present. I don't know if any of you have been to any appeal hearings. In Erie County, it's a 3-person board that is appointed by the county council. In many many counties, the board of, like Crawford County, the commissioners sit as a board of appeal. Same thing in Warren County, same thing in Mercer County. The commissioners are sitting at the board as the Board of Appeals. I've got my own personal feelings about that. The problem being the commissioners who know that they are making reductions, which is going to impact their total assessed value, which means they're going to have to adjust their millage rate to make up that lost revenue from any tax appeal reductions. Erie County, you've got 3 people that are appointed. One is an appraiser. 2 of them are people that are actively involved in the real estate business. And I got Scott Moss, who's the chief assessor in Erie County, also does not get caught up in the what impact is it going to have upon the millage rate. My experience in Erie County is they are driven by, is the assessment appropriate? Is it based on market value? And they're pretty good about it. They don't get caught up in the political atmosphere of, what's it going to do to the millage rate. The answer is have periodic reassessment. That's the answer to these periodic problems. Like I said, what evidence do you have? It really somewhat depends upon the complexity of your particular case. If you can demonstrate, in my opinion, if you can demonstrate to the Erie County Board of Appeals that you just bought a property, had been on the market, provide them listing agreements and statements from your broker, or bring them along with you. If you happen to have an appraisal, maybe from your financing, that type of evidence is normally going to be sufficient to convince the board whether you got a legitimate appeal or not. And again, that is not the case in all counties. A couple of years ago, there was a company in Meadville called J&J Meatpacking. The Times Publishing Company bought this property. It's located right behind the sheets as you're entering, just before you enter Meadville. The Times operated the facility for about 5 or 6 years. It's primarily a distribution facility. They made the decision suddenly to close it down. They actually retained our company, and George Trucco, we co-brokered the sale of that property. And we ironically closed on August the 31st in Crawford County. The filing date, the date that you're supposed to try to prove, is September the 1st. So Trucco and I are thinking, for the new owner, it was a Channellock subsidiary who bought the property. We've got evidence as to what the Meads paid for the property. We gave them a financial statement, every nickel that was put into that property during their ownership, the listing agreement, offerings, how long everything, you name it, and we provided it. Board no changed it, had a discussion with the assessor afterwards, and they said, sorry, not making any adjustment unless you go out and get an appraisal. So the philosophy of these boards is different. In Erie County, they'll listen to the property owner on an informal basis. If you're in Crawford County, you just might as well resign yourself that you're going to have to spend money to have an appraisal. Who needs to attend these appeal hearings? And again, it's in my opinion, goes to the complexity of the case. People think that they have to be represented by an attorney. If you own the property and it's in your name, you can represent yourself. You can bring somebody else to assist you, be it appraisers or whatever. You do not have to be represented by an attorney. That said, if the property is owned by a corporation, you cannot, which is a real rub, because you could be you can be an LLC. You must be represented by an attorney. There was a case down in Westmoreland County. It was a guy named Rogers who was doing a lot of appeal work, and make a long story short, ultimately Commonwealth Court said he was acting as an attorney and practicing in an unauthorized practice of law, representing property owners who own corporations. That's when the rules changed. If you're a partnership, you can represent yourself. If you're an individual, you can represent yourself. But if you're a corporation, you're going to be needed to be represented by an attorney. What are your options if you're dissatisfied? Well, you can wait it out. You can come back the following year and reappeal again. Or if you're dissatisfied, you can take an appeal to the Court of Common Pleas. That's where you're gonna, you can technically represent yourself. I would never ever encourage somebody to do that. If you took an appeal from the local board to the Court of Common Pleas, I would certainly encourage you to engage an attorney to do that. The problem is it's the economics of it. If you're involved, I was involved in the Sunrise Assisted Living tax appeal a couple of years ago. In that case, we were talking about $150,000 of annual taxes that were in dispute. It's obviously significantly different if you've got a $150,000 piece of property and you're looking for a $20,000, $30,000 reduction in your assessment. What you have online is $500, $600 in annual taxes. That's where you have to sit back and weigh is it worth pursuing it and going that next step? And again, it depends on the county, because again, my experience has been Erie County has been pretty good in terms of being reasonable, but you got to support it. You got three people that are knowledgeable, they know the market, and they'll adjust it accordingly. Probably only one other thing, I don't know, time-wise, I know I'm trying to limit myself about 15, 20 minutes here. One other thing that will impact your ability to get a reduction. If your property is encumbered by a long-term lease, and this is probably going to go more to commercial property owners than it is to apartments. I'm not talking about you own a 10, 15 unit apartment or two-family home or something like that, that you've got annual leases, or small commercial properties where you've got, 2-3 year leases. I'm talking about if you've got a Walgreens, this Sunrise Assisted Living, which I was talking about, was encumbered by a long-term lease. There has been Commonwealth Court decisions that basically say the Board of Appeals has to look at the economics of the particular property. So you could have a Walgreens that's encumbered by a long-term lease that indicates a value of substantially more than the CVS that's across the street, that's corporately owned, that is not subject to a long-term lease. What can that mean? That means you could have a McDonald's encumbered by a lease next door to a Burger King that doesn't have a long-term lease because it's owned by the franchisee, and have substantially different assessments, which a lot of people will argue that it doesn't seem fair. The underlying ground value is the same, the building size is the same, everything is the same, yet one assessment could be double the other. But again, the appellate courts have decided, and again, we're talking about probably not a majority of people that I'm talking to right now, but if you've got properties that are encumbered by a long-term lease, it could have an impact upon your ability to appeal that assessment if it wasn't encumbered by that long-term lease. I don't know at this point where else you'd like me to go. I think that give you a general idea of what's happening in this market and what the procedures are. And I guess maybe the next thing, if anybody has any questions, I'd like to reach out to you and see if I can address them.
I'd like to encourage, if anyone has any questions, to please enter them in the chat, just to everyone in the room. That way we can read it. I started you out with a question to give people a chance there. If you can read the first one there.
If you think your property is overassessed and you appeal, and if you're wrong, can they raise the assessment as a result of the appeal? The answer is yes, they can. You just don't want to arbitrarily go in and appeal for the sake of appealing. There's been property owners that I can tell you specifically that got burnt because they went in, they thought, hey, I'll give it a shot, see if I can get my assessment reduced. There was a commercial property that's currently some vacant land located on the northwest corner of 12th and Peninsula Drive. That property owner went in, and that's exactly what happened. And the school district intervened, and it turned out that they ended up getting their assessment increased. So if you're going to appeal, make sure you've got a very good, strong basis for that appeal. Where is a common level ratio available, and when is it updated? As I said, sales data is submitted to the State Tax Equalization Board on a monthly basis. The board by July the 1st of every year will publish what that common level ratio is. And quite frankly, if you just go online and put in PA common level ratio, you can click on their website, and it will tell you what. I'm glad, Jerry, I'm glad you asked this. It's going to give you the common level factor as opposed to the common level ratio. The common level factor is nothing more than the mathematical, it's the inversion of that number. I know I guarantee I've got people confused. Go on the Erie County or go on the State Tax Acquisition Board. You see that that factor, and it's like 1.2. So if you took your assessment and multiplied it by that factor, it's going to indicate what type of a value is indicated by that assessment. It's the same. And if you took that factor and divided it by the number 1, or I'm sorry, if you took the number 1 and divided it by that factor, it's going to give you the 86.2%. It's the same difference.
Bob, I
Yes.
think probably the easiest way to find it, you know, I mean, yes, you can go to the website, but you could just call the assessor's office and ask them. They're required.
Oh,
to-
sure.
It's public.
Oh, yeah.
Public record.
Oh, yeah. I got to say, the Erie County Assessment Office, there's only so much that they can put online. But if you go down to that office, they are, Scott this is public information. Whatever we can provide you, it's available. If we have it, we'll make it available to you. They are very, very accommodating. Not necessarily every place, but Erie County is, in my experiences. What was the name of your company again? It's Assessment Evaluation. Just Google it, you find it. When is Erie County going to do the next reassessment? Scott indicated that they are already gearing up. Just backtrack a second. I mentioned that Erie County had hired a company, Cold Air and Trumbull, in 2003 to conduct their reassessment. Between 2003 and 2013, Erie County made a very substantial investment into technology. And because of that, they are basically taking this sales data and inputting it into their database. And they did the last one in 2013 in-house. And there's a mathematical analysis that you can do, and it will tell you how close you are after you complete your assessment. Basically, did I do a good job or not? It's called a coefficient of dispersion. I was an English major, all right? I was definitely not a math major, but what it is doing, it's measuring effectively the accuracy of your results after you've conducted that reassessment. When Erie County finished theirs in 2013, they call COD, coefficient of dispersion, it was like 96%. And boy, when I went to school, if I came home with a 96% on a test, I felt pretty good about it. So you've got the technology to do it. You can be pretty accurate. Are there outliers after a countywide reassessment? No question. But you're going to find these mass appraisal companies can do a good job of getting it right. I recently purchased 8 exempt buildings. I'm selling one and putting 7 on the tax records as normal rentals. What should I do to anticipate the new assessment for these buildings? Erie County, and I sure hope Scott Moss isn't listening, but Erie County takes the position that the assessment that is associated with an exempt property usually does not represent anything close to what the market value was at the last countywide reassessment. They understand that. And to be honest with you, if you're a school district, you're a church, you're a tax exempt organization, and you are 100% exempt, do you think the bishop cares that St. Peter's Cathedral at 10th and Sassafras is assessed at $1 million or $100 million? Absolutely couldn't care less because it's exempt. So Scott takes a position that we are going to remove that exemption once it becomes taxable, and we're going to take a look at what truly should that market value be. It kind of breaks the rules of you should technically, that assessment, that exempt assessment should represent current market value, but I think it's generally accepted it doesn't. So I don't want to say he breaks the rules, but I think he stretches it a little by technically saying I'm going to re-examine these exempts and get them taxed appropriately. Apologies because I joined late. Am I understood that you have a company that evaluates assessments? Yes, I do. Assessment evaluation. I'm not on here to muster up business, but thank you. If you ever want to give me a call, be more than happy to talk to you about it and the process to go through. I mean, I think there's a lot of times the people could represent themselves or have, especially if you know somebody who's a broker or sales agent to assist you, or or appraisers. Again, in Erie County, you don't have to. Don't be intimidated by the process. It's very informal. It's very casual. These people, they understand the apprehension a lot of people have, and they're happy to work with you.
Bob, I have a general question, but it's a little complicated to try to type it out there.
Sure.
Let's say you are the owner of a property that's, you bought it for $2 and you own it for maybe 20 years and eventually it's assessed at $3 and maybe $4, and then you sell that property to somebody else for $5. And then, because that's the market value. And
Right.
then the school district gets upset and says, you know what, this property was assessed at $3, but you bought it for $5. So we want to assess it at $5 and have you start paying the tax at $5. And so they do that and you fight it, but they keep it at $5. So the question is this: let's say several years later, there's a countywide reassessment. Meanwhile, your property is really worth about the same as a bunch of other properties that are still assessed at $2 or $3. Would you expect that after the assessment is done, that these properties all then kind of end up with about the same assessed value going forward for the next 10-year period?
A couple of things, so you don't have any misunderstanding. A school district that files an appeal cannot increase your assessment. They have the same rights and same obligations as you do as a taxpayer. And I'll be candid. I mean, I do a ton of work with the city of Erie and Mill Creek, and every year we get a listing of every property that sells in Erie County, and they basically have they hire us to analyze these to determine if in fact they were legitimate sales. But the school district can file an appeal, and they can go to that appeal hearing just like you can and present evidence to support the fact that that property that you bought for $2 or for $5 and it's assessed at $2, it should be assessed at $5. It is the Board of Appeals, not the school district, who makes that determination in doing it.
Right.
What should happen over time, and see that's, I wish the state of Pennsylvania would mandate periodic reassessments, because what happens in the example that you're talking about is if you're in Crawford County and the county doesn't reassess, I do not believe at this point in time any school district in Crawford County has been challenging assessments. But if you don't have reassessment, your assessment goes from $2 to $5 based on the appeal the school district filed, and everybody else stays at the $2 because they didn't challenge those other assessments, and it goes on for 51 years.
Yes, and they didn't challenge them simply because they didn't change hands.
Right.
And it was the fact that the property would have changed hands that was brought to their attention that, hey, this property was sold for $5. Maybe we should assess it at $5. So that's really my question is does it get evened out at some point, like every 10 years or whatever? Would they say, hey, this $2 property and this $5 property really are the same thing, so they should be assessed at the same amount?
Precisely the reason that you need periodic reassessment. Now, just one other thing, when Erie County, I'm sorry, when Erie County in 2003 had their reassessment, this Cole, Layer and Trumbull, to be quite honest, they totally blew it on the lakefront properties. Just so you understand, mass appraisal, some people think that there's 122,000 pieces of property in Erie County, that the assessment office is going out and individually valuing each property based on, you know, how much did the property across the street sold for. They utilize mass appraisal techniques. And basically what you try to do is you try to take neighborhoods that have similarities and you group them together. In the city of Erie, if you're familiar with Erie, you could group Frontier with Glenwood and with Glenwood Hills. And you're going to find there's probably a lot of similarities in those three neighborhoods, even though physically they may not be located. One's in Northwest Erie and the other's in Southwest Erie. And you can do the same thing with, you know, with subdivisions, and you have databases that have literally thousands of properties in it, and you compare how much property is sold and how much is a two-car garage worth compared to a three-car garage, and that's what mass appraisal is. When Cole, Layer and Trumbull did their countywide reassessment in 2003, they took all the properties that were on the lake base side and the lake side, and they grouped them with the properties that like were on the south side of South Shore Drive, which are absolutely two totally different value sets. Both Mill Creek and the city of Erie challenged literally every single property that was located along the bayfront. So it wasn't based on sales. It was based on, I mean, they used sales to support what they felt the other ones should be worth. So yes, they are looking at sales, but they are also taking a look at, are there other properties that are similar to it that are inappropriate? So it's generally sales, but not exclusively, I guess is what I'm trying to say.
So if you wait for the next assessment, you can expect that your, let's say it's something very common, like a 4-unit townhouse type freestanding residential rental property. It's very easy to comp that. Would you expect that it would that all of them would end up at about the same assessment, plus or minus their little, you know, differences based on lot size and other things like that, square footage?
Right, and I think that's my point. I don't make something that is I think relatively similar, make it too complicated. You know, if the market is saying a 4-unit townhouses is worth $60,000 a unit, you can compare it to other ones that take a look at what is the rents for ones that are selling for $50,000 a unit, and what are the rent structures of the ones that are selling for $70,000 a unit, and which is exactly what an appraiser does. But if the rent structures are the same and locations are relatively the same, the assessments are the same. The one thing you cannot do is you can't go in and say, here's the property across the street and it's assessed 4 units and it's assessed at $40,000 a unit. And I just bought mine for $60,000 a unit, and the school district's contesting my assessment based on what I just got done paying, the $60,000 a unit, because here's the other guy that's at 40. Doesn't work. And there's actually been appellate court decisions on this, and they have taken, it was ironic, it was in a condominium complex where school districts had gone after units within a condo complex and got the assessments increased, and the property owners went to court and said, wait a second, there's other condos that are identical. We're in the same condo complex. They sold there's no difference between them. They're assessed at 40, I'm assessed at 60. And Commonwealth Court said, absolutely. And the answer to that is the county should have a countywide reassessment. So does that seem unfair?
Would be that when they do the reassessment, everybody gets assessed at 60,000.
Correct.
But
yes,
you know, that may not be that. It could be that the guy that's currently assessed at 60, his taxes may go down a little bit, and
right,
the people at 40 would go up a little bit, so that it evens out, because you might want to talk about how the reassessment can't actually increase the total property tax revenue to the taxing body by a certain amount.
Yeah,
percentage.
it's a misconception. Thanks. I'm glad you brought it up. It's a misconception a lot of people have. After a countywide reassessment, the school districts, municipalities have to adjust their millage rates. So in total, it is revenue neutral. They do have some variance. I forget what there's a certain percent that they're allowed to increase. But you could imagine between the 1969 and the 2003 reassessment in Erie County. I mean, the base assessments they quadrupled, but the taxing districts had to roll back their assessments, so ultimately it was revenue neutral.
They had to roll back their millage, you mean?
And roll back their millage. So yeah, there's no question. At the end of the day, there's going to be some people whose taxes are going to go up, some people are going to go down, and some that aren't going to have a major change. Which I don't get it in Pennsylvania. Like I said, in Ohio, I'm doing some work about 5-6 properties in Lorain, Ohio, and in Ohio, they have to reassess every 3 years. They don't physically have to go out except every 6 years, but if they physically reassess today, and then 3 years from today, they can basically do, I'm going to call it an in-house. They can do it at a statistical analysis to adjust the assessments. And then the next 3 years, they have to physically go out. The big advantage is you don't get these huge swings in values, and you consequently don't get these huge swings in tax bills. I'm doing some work, just finished a couple of projects up in right outside of Buffalo. I think about this, in New York State, they don't even assess by county, they assess by town. So if you go to Sherman, New York, they have their own assessor. The town of Mina has their own. Every town assesses town by town. Now, the only good thing is a lot of towns have hire the same assessor to do their work. But when a town does do a periodic reassessment, they will send a notice to the property owner saying, here's what your assessment was. Here's what it's going to be after the reassessment. Here's what your millage rate was. And here's what the millage rate is going to be. Consequently, this is going to be the impact. I really think that if more of these counties was proactive in trying to educate the public, you wouldn't get this opposition. Now, you're going to get problems when you wait 51 years, like Crawford County has, or whatever it is, 20 or 36 years in Warren County. But in Erie County, you didn't have the backlash that you did between 2003 and 2013. Any other thing, just one other thing, even when they did the reassessment in both 2003 and 2013, you had the opportunity to informally meet with representatives from the assessment office prior to their formalizing that final assessment. So you basically got a bite at the apple saying, hey, wait, that's going to be my new number. I think you're wrong, and this is the reason why. And in many cases, they would change it. If, again, you got to support it.
Bob, I guess the uptake, the most important thing that people should really take from this is that just because you have a really precise idea of what the market value of your property is, either because you just bought it or whatever, and if you know what the assessment is, and you might know what the guy across the street his assessment is, that's not enough to determine whether you should appeal your assessment. You have to get other information, such as what is the common level ratio for the county? Am I overassessed compared with all the other properties in the county, which even if the county assessment office tells you that they are that they use a 100% assessment, that doesn't mean that they really do use 100% assessment. Does that make sense?
Absolutely.
Yeah,
And,
and don't appeal it just because you think you're right, unless you check these things out, because if you're wrong, they can actually raise your assessment. And if you don't appeal it, they couldn't raise it. They couldn't raise it.
I've got a question here. If you have a realtor do a market analysis and if feel you're overassessed, would that be enough to support a challenge to an assessed value? I can't guarantee you that in it itself, as well as I can't guarantee you that an appraisal in itself. But I'm telling you, in Erie County, you've got 3 people that are in the real estate business, and they know if that market analysis, I don't want to say legit, but is supportable. My answer would be yes. I do not get intimidated by this, that you have to hire attorneys and spend a lot of money going through appeals. And again, I mean, it depends upon the complexity of the property, but I'd be willing to bet you, hey, anybody that's listening, you have a pretty good idea as to what your property is worth, and know, because you know what sells in the market. I mean, I tell people all the time, I mean, if I'm doing an appraisal and I'm doing vineyards, I'm not an expert in vineyards. I call up Bob Mazlik because Bob knows how much vineyards are worth. I, as an appraiser, am relying upon people that know what these what properties are worth. And Bob could tell you what every vineyard that's sold and what it's worth per acre. And I think that's the same thing with so many of you. You know what your property is legitimately worth, and a market analysis is that, in your own personal knowledge in many of these cases is sufficient.
Yeah, but
and I am going to say,
know
to
what
anybody,
the common,
if you want to ever reach, if you ever want to reach out to me,
common level ratio.
yeah, you want to know common level ratio or something, shoot me an email. No big deal. I'm happy to share whatever it is. Would you file an appeal in 2022 or wait until countywide reassessment is 2023? I'd file it in 22. Remember, this is as much as they hope to have an assessment completed or done in 2023. You never know what the position of the new county executive is going to be. Well, do we kick the can down? Let's do it in 2024. Let's do it in 25. That's the risk. So no, don't wait. If you feel you got a legitimate basis for an appeal, which also is, I think, if you can convince the board that in 2022, this is what the appropriate assessment should be, they give you a reduction. The next year, Erie County conducts a reassessment, and it's something significantly different from what the board just gave you. I don't think you got any better evidence than that to go to the informal hearing after they issued these preliminary numbers and said, hey, I just got done going through it. I don't want to say guarantee, but feel very strongly that they'd make that adjustment.
Can you say again, are they doing a reassessment in 2023?
That's their hope.
And
that is
there
their
a mandate that it has to be done every 10 years that when they?
No, there's no mandate period.
Okay.
That is the problem in Pennsylvania. It is strictly at the discretion of the county. And that's why, like I say, Crawford hasn't had one in 51 years. There is no requirement for periodic reassessments in the state of Pennsylvania. Can
you tell us how your company charges for representation at an appeal?
You could either hire us to perform an appraisal for you and attend the hearing. And if I go that route, I'm simply going to tell you in advance, a flat fee, non-contingent basis, this is what it's going to be. I have not done as much in Pennsylvania that I have done in other states, but I've also done appeals on a contingency basis. But if that's the case, what's going to land up happening is I'm going to basically also hire probably hire an appraiser to do it. And again, it really depends how complex it is. I would say generally, and it's because Erie County's assessments they just are relatively close to market value. it's something we should talk about. But I'd be willing to bet you that in the majority of cases now in Erie County, because the assessments aren't that old, just an appraisal is going to be sufficient to, as a basis. I mean, to be honest with you, I get people, I get a lot of calls, I get a lot of emails, and I said, look, before we do anything, why don't you give me your address of your property. Let's take a look at what it is. And before we go spend any time, any money, and whether you want to file an appeal or not, let's take a look. I'm going down to Meadville tomorrow morning. I got a couple that's in Florida. They think they're overassessed, and they get into how much it's going to cost me. And I said, well, I'm in Meadville enough. Let me go through your property. Let me see what you've got. Let me give you a call, and let's figure out if it's worth pursuing or not. If it is, great. We'll work out some type of a fee arrangement. If it isn't, don't worry about it. I'm in Meadville enough anyway. I'm doing work in Lancaster. Like I said, we're doing work in Indiana, we're in Buffalo, we're in Rochester. I mean, I'm out enough that I'm more than happy to do that.
So just to be clear, if you had an appraisal of your property that came in at $100,000, you would hope that your assessment is not any more than $86,000 on the tax record.
Correct. Right.
Otherwise, you're probably paying too much.
That's correct. And of course, if your $100,000 property is assessed at $66,000, don't go in and say, well, gee, the guy across the street, that's, I think, the point that John's trying to make, is he's the same as mine, or he's at 50,000. You cannot base an appeal on comparable assessments. It's got to be somehow tied to what the current market value is, because you always run the risk that a municipality or school district is going to say, whoa, no, you're trying to get a reduction for a property that is might even be underassessed. So
what is the threshold that the school districts, for example, are using right now to determine whether it's worth going after a property owner for a reassessment? In other words, if it makes them $500 more a year in taxes, is it worth the school district's effort?
This is kind of a moving target between different school districts, but I can tell you last year that Erie, Mill Creek, and I can't speak for Fairview, but Erie and Mill Creek used $1,000 school districts used $1,000 threshold. So if it appears that they would generate $1,000 of additional school tax, they'd pursue the appeal. If not, they won't. So I mean, it really gives you some wiggle room there. So they don't want to get involved in trivial. You're underassessed, and we should generate $150 more. It's not worth their time and effort to do it. They'll let those slide.
And that $1,000 isn't $1,000 in assessed value. It's $1,000 in their school tax.
In tax
correct.
revenue.
Yeah.
Right. Tax revenue.
So it have to be a substantial amount.
I mean, I can tell you, I think Mill Creek, it would have to be, the variance was something like, don't hold me to it exact, it was like $72,000, unless there was a difference in market value of probably $75,000. Mill Creek School District wasn't even looking at it. So I mean, you've got, I wouldn't be overly concerned about school districts going after you unless it is substantial.
Okay, well, I would like to thank Bob for coming and meeting with us tonight. Bob, you always do a great job, and it was really good to see you again. I haven't seen you all year.
Or anyone else.
Or
No,
anyone
I enjoy
else.
it.
Okay.
It's a subject that's near and dear to my heart. I'm involved in it literally on a daily basis. I'm more than happy to, if I can inform you, be happy to. And like I said, if somebody's got a question, shoot me an email, give me a call. I'd be happy to talk with you.
Well, this guy really is the expert. So, give him a call if you have a question on it. And
Okay.
thank everyone for attending. Joanne, if you want to close the meeting out at this point, we can do that.